Paul Friedl, one of the leading scholars in privacy. Would I be right in thinking this, Paul?
I wouldn't call myself a leading scholar. I mean, it's always best to think of academia as a collaborative enterprise. Can we even measure social norms? Is this just not just like some kind of boo-hoo about stuff that doesn't really exist? So what judges sometimes do is they don't ask what do people expect, but they ask what does a reasonably informed person expect cognitively? Just as with other standards of reasonableness, reasonable expectations as well have this kind of somewhat fluctuating or hybrid nature. Regarding the European Court of Human Rights, I think there's gradually a shift away from cognitive expectations to normative expectations. There is a quite noticeable shift now from the kind of overall normative ethos that the GDPR kind of operates into what is now being done with the AI Act. If I would talk to a legislator, that's what I would ask him, like, how can we kind of make progress with that? How can we democratize data governance or tech governance or something?
Welcome to the Just AI Jean Monnet podcast, where esteemed experts from across the globe address the most pressing issues on AI technologies, their regulation, and the resolution of disputes involving them. What level of privacy protection can be reasonably expected when personal data is processed? This is the central question Dr. Paul Friedl explores in his latest book, Reasonable Expectations of Privacy, with special regard to European privacy and data protection law. The issue is twofold within normative frameworks like the GDPR, the EU Charter of Fundamental Rights, and the European Convention of Human Rights. On the one hand, individuals may reasonably expect that the processing of their personal data, even when based on consent, respects their right to privacy. On the other hand, the scope of that processing can sometimes exceed what one might have reasonably expected. Drawing the line between lawful data processing and the expectation of privacy it warrants has been a long-standing challenge for both the European Court of Human Rights and the Court of Justice of the European Union. These courts have worked to clarify not only what individuals actually expect, but also what they are legally entitled to expect under privacy-protecting frameworks in instances where their data is being processed. Dr. Friedl's book offers a careful and insightful analysis of this evolving case law and is a must-read for anyone interested in data protection, privacy, and emerging technologies. So join us as he shares his findings on this episode of the Just AI Jean Monnet Center of Excellence podcast.
Welcome to yet another episode of the Just AI Jean Monnet Center of Excellence podcast. And today it is an extreme privilege and pleasure to welcome Paul Friedl, which I would say that is one of the leading scholars in privacy and GDPR and fundamental rights currently. Would I be right in thinking this, Paul?
I'm a scholar in these fields. I wouldn't call myself a leading scholar for sure. I mean, it's always best to think of academia as a collaborative enterprise, right? So I guess I'm trying to add something to these fields and I guess tech regulation more broadly also, but leading scholar, personally, I won't call myself that, but like if you want to do that, that's on your call, I guess. Yeah.
Oh yes, I do want to do that, especially considering the book that we will be discussing today, which I will announce in a minute. But before I do, just a few biographical points on you. So you have completed your PhD at Humboldt University in Berlin, and this was followed by a postdoc at the Karlsruhe Institute of Technology, and you're also an affiliate researcher at the Information Law Institute at NYU. You have published extensively on issues dealing with privacy, internet governance, data protection, and fundamental rights. And the reason, now I'm coming up to the key reason why I think that you're one of the leading scholars in data protection in Europe is your magnum opus, who was published by Springer a few months ago. And it's titled Reasonable Expectations of Privacy with Special Regard to European Privacy and Data Protection Law. So congratulations on the publication of this book, which I thoroughly enjoyed reading and which we will mainly discuss today. So this will be the kind of like the key topic of discussion in the podcast. But before we do, I always begin by asking our guests to briefly introduce themselves and particularly to explain how they became curious about their specific topics of research. So how did reasonable expectations of privacy come about?
Right. So yeah, I mean, yeah, as you've mentioned, I guess you could call me a scholar of data protection law or tech regulation law, more broadly. I think why I'm interested generally in these issues is because I've just always been very interested in technological developments, and this is kind of um, has often been like the driving factor behind what I like the research projects that I want to engage in. So naturally, if you think about these issues, obviously the whole field of like data protection law, privacy law is one important element of tech regulation in the year 2020, 2025, whenever I started this project and when it's finished. And I think why I got interested in reasonable expectations of privacy in particular is that it's really a quite kind of universal principle that pops up all over data protection law and privacy law. Like, I mean, we might dig into this later also, but I mean, it originated kind of from American constitutional law, but then spread out into other privacy frameworks, data protection frameworks, and it's kind of this notion that it seems like judges and other legal administrators will kind of resort to when they're out of other tools or when they don't really know how else to approach a specific question. So from that perspective, I just felt like it would be interesting and worthwhile to engage with that idea, to kind of take a harder look at it, what it does in judicial practices, and also what the different justifications for these different interpretations might be and stuff. And also the other factor why I was kind of interested in it is because it allows you to engage with theories of privacy and theories of data protection and theories of regulating privacy and data protection law. So that was kind of the other interest that contributed to that project, as well as I guess a certain kind of interest in like legal theory and jurisprudence and that kind of stuff, which obviously that term also has a lot to do with, as it's quite vague legal notion, which then kind of has relations to legal theory in quite interesting ways, I think. Yeah.
Yes, definitely, and we'll kind of unpack those ways and those legal theories in a minute. But before we do, you mentioned it also in the book that the origins of the reasonable expectations doctrine are in the U.S., specifically the Katz case. So could you briefly explain like what this case was all about and why is it so groundbreaking? And one of the questions that I asked myself was, well, we kind of know that it is with this case that there was a constitutional protection that was afforded to privacy, but does that mean that before Katz there was no such protection in the U.S.? And then how did this case reverberate throughout the rest of the world, particularly Europe?
Right. Yeah. Super interesting question. So I mean, yeah, what is the big innovation through that Katz brings about? So this is the judgment is from 1967, and it concerns different forms of police investigation measures, and essentially what the doctrine it kind of essentially concerns the interpretation of the Fourth Amendment to the U.S. Constitution, right? The Fourth Amendment protects people from searches and seizures, and it is the main amendment that is kind of determining whether people are safe against certain kinds of state intrusions, mostly police interventions, right? And before CATS, this amendment was interpreted as protecting only against physical trespasses. So what you needed for something to be seen as a search was some kind of physical trespass. So of course, a search, like if we think of what a search looks like, I guess all of us have a pretty kind of clear picture of it. You imagine someone busting through a door and like rummaging through someone's papers. But of course, over the decades, other types of police investigation measures became quite important too, which did not involve any kind of physical trespass, right? So this is eavesdropping on people, very importantly also obtaining documents from third parties, so banking documents or what have you. And of course, all of these things would in a classical understanding not constitute a search or a seizure. And what CATS then does is, so CATS concerns a certain form of eavesdropping, essentially. And what the judgment, and this is actually a dissenting opinion that then in the later jurisprudence of the Supreme Court becomes the kind of defining idea, is that it says that we don't look at physical trespass anymore, but we just look at if there has been a reasonable expectation of privacy against a certain form of police intrusion. So this kind of dematerializes privacy protections, whereas before there was only a protection of your privacy when there was some kind of material intrusion into your belongings or your house. Now we're kind of dealing with this general notion of, has there been a reasonable expectation against that specific form of state surveillance? And this is an extremely important development for US constitutional law, obviously, and then also goes to kind of influence other legal orders. But I think it's also like kind of recently I was actually thinking about this. It's also interesting as one moment of the constitutionalization of privacy, right? And yeah, I think it's very interesting that of course in different legal orders there's different moments when a certain when claims to privacy or claims to fair data processing or such issues become elevated to a constitutional protection, and this is kind of probably the defining moment for the US legal system, and then obviously other legal orders have other moments and might also have a different framing, right? I mean, like in Europe, we have a fundamental right to data protection, which is something different, but kind of
I like, and you're so right now, I'm just remembering reading this in the book, but I think the analogy for the legal justification of the reasonable expectations doctrine was property law. Am I correct?
Right.
Saying like the data, you own your data, right? So it's something that you own, even albeit an immaterial good, but still it's something that you have ownership over. And so that, if I recall correctly, that's the analogy that kind of allowed this doctrine to kind of come to the forefront, right?
Yeah.
So, but like now, and you mentioned earlier that you were interested in various theories, and my God, that's reasonableness as such, and reasonable explanations. Well, explanations too, but expectations as well, which is the topic of our podcast today. Reasonable expectations do kind of lend themselves to being theoretically analyzed, right? And in that sense, your book is super insightful, multi-layered, very three-dimensional, the type of scholarship that I'm drawn to kind of naturally. But so before we get into like the various models that you suggest in the book, you start off with this very generic concept of reasonableness, right? And you tie it to the standard of reasonable person, which is open-ended.
Yeah.
And then at some point at the beginning of the book, you mentioned that the reasonable person standard is either an empirically observable mean, so it's the average person, or it's like an ideal. So it's either something that is empirically verified or something that is normative, right?
Right. Yeah.
And so this kind of shapes the what you will then go on to formulate as the 4 models of reasonable expectations, which are cognitive, normative, hybrid, and two-tier. And we're going to comment a little bit on each of those. So let's begin by the cognitive model. Like, how would you explain in very broad brushstrokes the cognitive model?
Right. Yeah. So it's exactly as you just mentioned, that just as with other standards of reasonableness, reasonable expectations as well have this kind of somewhat fluctuating or hybrid nature, where sometimes it points to an average mean, and sometimes it points to something that is more normatively determined and ideal. And then how this kind of plays out for reasonable expectations is that we first, as you just mentioned, have what I in the book call the cognitive model. And here, what judges do when they employ this kind of model, so you can kind of observe this, like what I do in the book is just analyze quite a lot of judgments. And it turns out that sometimes judges employ what I call this cognitive model. And what they do then is they ask, what kinds of data processing do people expect, like just from a factual perspective? And then if what we're now kind of looking at was expected by people or is generally expected by people, then that form of data processing will be lawful or legally acceptable. And if it's not in line with what people expect, then it will be unlawful and legally not acceptable. So we're looking kind of at people's cognitive expectations. That's why I call it the cognitive model. And we take that as our threshold for the admissibility of certain types of data processing, from a legal perspective. So that's what the cognitive model kind of describes.
Right, but as you also mentioned in the book, the cognitive model has kind of like a congenital difficulty, right? Which is empirically verifying what a person can cognitively be warranted, or justified in expecting, right? So to illustrate this, could you maybe comment on some of the cases that you take as illustrations of the cognitive model? I think, although you also refer to the European Court of Justice case law for the majority of your book, you actually, correct me if I'm wrong, but you mostly refer to the European Court of Human Rights, and this was particularly insightful for me. And so to illustrate the cognitive model, for example, you cited Halford versus UK, Barbulescu versus Romania, and Antovic and Mirkovic versus Montenegro. So what would be, if you were to maybe describe some general trends of the European Court of Human Rights in terms of how it interprets and applies this cognitive model, what would you say?
Okay, yeah. Well, I think the first thing to it might seem as a minor point, but it is actually not such a minor point. So when I speak about the cognitive model, I don't speak of an interpretation where we're asking what cognitive expectations are justified. I just speak about like judges looking at what people actually expect and not thinking about whether that expectation is justified or not.
Right.
And this generally then has the effect that it has the effect in case law that judges will look at whether people were informed about a certain type of data processing, and if that is the case, that that data processing is in line with their expectations and it will thus not violate a reasonable expectation. So for example, one case which I think also generated quite some legal commentary, I think, is Babulescu versus Romania, which concerned like surveillance at the workplace, and there were a majority opinion and then a dissenting opinion as well, and that dissenting opinion kind of just stated that the employee in question had been informed of that kind of surveillance, so there was no expectation. He could not harbor, or he did actually not harbor, an expectation of privacy in that context, and therefore there could be no intrusion into Article 8 of the convention. Another case that I also found pretty interesting because it comes from a different angle, but it again relies quite heavily on this notion of reasonable expectations, is a decision by the German antitrust authority, which I think it was 2019 or 2020, kind of looked at data processing operations at Facebook, and especially how they kind of integrated data processing from Facebook with their other services, Instagram, to a certain degree, even WhatsApp, I think. And there they also said that users just are not aware of that, in the broader kind of not aware of this form of data processing, and therefore they have a reasonable expectation against it. And therefore that processing contradicts the GDPR in that instance. And yeah, maybe just also commenting on what you said about like the evidentiary issue, like how do we even know what kinds of data processing operations individuals expect? I mean, obviously that is one issue that then kind of comes up when we look at this cognitive model. I mean, I wouldn't say that it's like necessarily an issue that cannot be overcome, right? Because to certain degrees, we kind of deal with assumptions about, also informed assumptions about what people know, expect in many, probably all fields of the law to a certain degree, right? So it is, of course, an issue, but I guess it's also not, there are ways of applying this cognitive model in an authentic, and I would even say kind of convincing manner, right? There's a different issue of whether all judges will always kind of use that model in that way or use reasonable expectations in that way, but I think it's not kind of impossible to do that. Yeah, I don't know if that answers your questions.
Sure. No, it does. It definitely does. But as I was listening to you explain the cognitive model, I kind of thought about, would you say that there's a difference between being aware that personal data is being processed and therefore agree to it and kind of expect the data to be processed? On the one hand, and then on the other hand, the extent of the processing, which certainly Meta has been, kind of guilty of.
Sure.
not before. Yeah. So the second kind of leg of this argument would be like the proportionality dimension, right? Like I expect my personal data to be processed, but not to that extent, right?
Exactly. Yeah.
So,
No, that's I think that's a very that's a super important comment, because that very much determines what the outcome will be, right? Like if you if judges ask, well, do people expect Facebook to process users' data? The answer is, of course, yeah, everybody does that, everybody knows that, right? If the judges ask, do users expect Facebook to connect their phone number to their location and thereby deduce whether they are interested in ads for holidays in Croatia? Probably nobody really has nobody has that concrete of an expectation of what's being done with their data, right? So this is like an extremely important issue, like and an open-ended and difficult one as well. Yeah, it's the same issue that obviously you also, and you just alluded to this, you also get when you talk about like consent and what can people consent to, what level of informedness is necessary. It's essentially the same question in a kind of coming from a different angle, but yeah.
Well, speaking of consent as a condition for lawful data processing, so that kind of provides a beautiful transition to the next model that you suggest in the book, which is the normative model. And then you say, well, under this model, the question that we ask is, what should individuals expect, right? And so, but to state that something is normative means or implies that there's a normative benchmark, you know, against which I am maybe not justified, but you know, I can legitimately rely on XYZ to expect XYZ.
Right. Yeah.
And so amongst those benchmarks, you cite two, one of which is pretty obvious, and that's positive law. So obviously, if I want to, or if a court wants to kind of discern and elucidate a reasonable expectation, they would arguably look at the law and see what the law kind of allows for individuals to expect. But then, if I'm not mistaken, in your book, you're kind of, and rightfully so, critical of positive law being kind of like the sole reference of fostering normative, reasonable expectations.
Right.
And so you say, well, what about non-legal factors like values and facts? And then my next question will be on social norms. But could you please comment a little bit about like the positive law aspect of as a component of this normative model, you know?
Right. Yeah. Yeah. So yeah. Right. So first of all, maybe just to like introduce the framework. So I kind of I juxtapose the cognitive model with this normative model, and within the normative model, what judges do is they don't ask whether people actually expected something, whether they are aware of a certain form of data processing, but they ask, should they need to expect that form of data processing, right? Like essentially, is this form of data processing fair? Is it reasonable? Do we want to allow this? And yeah, as you also just mentioned, that's a kind of that's a question that you can have many thresholds to answer that question. One being positive law, and when judges then refer to positive law, essentially what they do is they try to, like, if we're dealing with say surveillance at the workplace, they look at other norms within labor law, for example, and kind of try to get some inspiration from those norms. Or you might look to consumer law, or as well as sometimes, like especially with constitutional protections of privacy. Of course, you might also say what is reasonable is what is determined by the lower level of law, right? So state law, for example, for the ECHR. Yeah, and I think this kind of this idea to look to other positive law as a source of inspiration for figuring what is a reasonable expectation is, at least in the kind of continental tradition, I think is a very kind of standard idea. What is reasonable is essentially what is kind of legally reasonable, right? A reasonable person takes their inspiration from the law, so what the law says is ultimately what is reasonable. And I think the issue that you run into when you adopt this kind of approach is that of course, other laws have been crafted in other contexts, right? Dealing with other issues. So the kinds of value judgments that have been made in these other norms might not always be transferable to a new form of data processing, right? Especially considering that data processing operations are a quite dynamic field, and there's quite a lot of development constantly. I think so what I think is then maybe the best argument in favor of being inspired by positive laws, that you say, well, ultimately it's the most democratic source of legitimation we have, right? This is a pool of normative inspiration that is democratically legitimized. We should be looking to this as a kind of benchmark for reasonableness. What I would probably object to that is that, again, this kind of sounds true in the first instance, but of course it kind of runs into the same issue, that what is democratically legitimized is this specific conflict that you were dealing with when you kind of crafted these consumer protection laws, for example. It's not necessarily given that the democratic lawmaker back then had these new issues of data protection in mind when they were crafting these regulations, nor that they want to kind of extract the normative principles that they enshrine to these new issues, right? So I'm not kind of, I think this looking to positive law can be one source of inspiration, but I would generally kind of hedge against thinking that we'll find all our solutions in the existing law. And I think, yeah, this is what few judges will also do. But it kind of pops up, and I think often it can also lead to quite misleading ideas. So I remember one case where the German federal court, the BGH, was kind of had to adjudicate on whether parents would inherit their or whether inheritors would inherit social media accounts or other kind of digital assets. And essentially what they do is then they just say, well, if all of this was printed out, then obviously it would like be a physical object, and that would then be implied in the whole substance of their inheritance. So there's essentially no reason to kind of deal differently with digital assets. And I think this kind of is maybe a bit of a crude and oversimplified way of looking at this issue. So I think that, yeah, that's the kind of issues that you might run into when you rely too heavily on positive law, I think, yeah.
Yeah, and I think, you touched upon a kind of an issue that that most of us run into at some point in our research, and that is not all normativity is captured by positive law, right? So there are normative reference, if you will, that exists, that are maybe more important, that exist outside of the scope of application of positive law. And in that connection, you mentioned social norms. And so I really found your developments on social norms, a reference to social norms within the context of this normative model, very, very interesting. But there again, you mentioned possibly two issues. The first issue is, again, empirical. How do you verify that something is a social norm?
Right.
And if you don't mind, I would like for you to kind of like maybe mention and comment on some of the empirical studies that you mentioned in the book, where like there are that actually kind of try to uncover how people identify social norms, or how social norms can be identified.
Yeah.
So that's the first aspect. And then the second aspect is something that you just mentioned, which is democratic legitimation, right? So social norms lack, in principle, that type of legitimacy from a positivist view.
Yeah.
So that is like the second aspect, the second portion of the question that I would like for you to comment on.
Yeah.
So what are your thoughts?
That's great questions. So I think this first aspect, like, can we even measure social norms? Is this just not just like some kind of boo-hoo about stuff that doesn't really exist. I mean, I always find this pretty interesting because at least like in the kind of European legal tradition, I think there's like a huge bias against empirical research for the first thing, and then because there's a bias against empirical research, there's also a bias against any kind of normative proposal that thinks that we should potentially rely on such research to, say, introduce social norms to our legal processes, right? And I think despite the fact that this bias is somewhat strong, there's also a long tradition of, especially in the privacy context, of trying to measure social norms on privacy. And yeah, I present a lot of that research, or I kind of try to summarize that research in the book. And essentially, like in the US, there's somewhat of a tradition from a legal perspective to do empirical research on social privacy norms, which starts in the 90s, and it's a group of researchers that kind of come from the same issue, namely they don't know what reasonable expectations of privacy are, and they start doing research, empirical research, surveying citizens on what privacy expectations they have. They look at both kind of their cognitive expectations as well as their what you might call normative expectations, what they find fair or reasonable. And what I find quite interesting is that of course, this type of research is not super challenging at the end of the day. Like, you can ask people if they think that they should need to download a contact tracing app, and that's like conforming to their reasonable expectations. That's really not that hard of a survey. And B, it's also quite interesting because what these researchers then did was kind of reiterate some of these surveys, right? And look at whether people feel the same way 3 years later or 5 years later, or what makes a difference. And they also show that you can kind of, like many of these results stand over time. So it's not just that, there is some kind of scientifically provable evidence that this is actually a persisting social norm, that people expect this kind of privacy or don't expect this kind of privacy, right? There is quite a lot of US scholarship on this. I think actually just recently I also saw some scholarship from Europe that also looks at privacy expectations, which I think is super interesting, that goes into data processing for insurance services, and what kind of privacy citizens expect vis-a-vis insurance services, and the different kinds of data that these services gather and process. But I think you also kind of asked how this can be introduced into the legal process, I guess, right? Like how this evidence can be made use of, or no?
Well, when I asked the question, for me, these were like kind of two portions that I didn't necessarily see interacting. But because I don't remember you mentioning in the book that the European Court of Human Rights has, or an American jurisdiction, I don't think, I'm trying to remember, but I don't think you're mentioning a case of where a court refers to a study to kind of attest the existence of a social norm, right?
Right.
Am I correctly saying this? Yeah.
No, this has actually happened. The Supreme Court, I think, twice has had these amicus curiae briefs, where they had groups of researchers conducting empirical research on what privacy individuals expected. I think one dealt with like GPS tracking or something, and the other one I don't really remember. I think it was on data retention or something, and essentially they they asked they asked these researchers to provide them with empirical evidence on what people expected, and these researchers came up with that evidence, and the court made use of it. And as far as I know, so the European Court of Human Rights has not done this. German courts have done this in other fields of law, like in trademark law. I think this is like there's some use because it's obviously quite central to like certain issues in trademark law. So it's not like usage of empirical surveys is kind of completely unheard of in court proceedings, but of course it's a rather uncommon occurrence. And I also don't think that it's the most practical way of making use of such surveys, I guess. But
yeah, definitely. I'm trying to think. But we will surely continue talking about your book and your other publications. But there's a few years ago there was a book that was published on legal standards in EU law and particularly good faith, proportionality, reasonableness. And in this book, so this was back in 2008 or 9. So it's over almost, I don't know, would you say almost 30 years ago, but certainly more than over 20 years ago. This book essentially part of this book was dedicated to how the European Court of Justice uses the standard of reasonableness. And it usually is, as you say, in certain areas of EU law, like consumer protection, IP, in the early days of the internal market, like even free movement of goods. But I don't remember there being any, let's say, statistics to kind of showcase market behaviors to say, well, this is what consumers are used to, like expecting from a product, from a trademark, from what have you. It was almost, I want to say, intuitive. The court kind of reasoned or interpreted the concept of reasonableness, I think, in connection a lot with the principle of proportionality and what you mentioned at the beginning of the book, in terms of like the average consumer would be, kind of confused if they saw a trademark that is similar to another trademark. So anyway, but yeah, so to your point, I don't think, or I'm going to check this after the podcast, actually.
Now that you're talking about it, I remember that there is so there was a preliminary reference once where a German court asked the ECJ whether like this kind of empirical evidence could be used in determining some kind of consumer standard. I guess that was maybe like unfair commercial practices or something, that field, I think. And I remember the ECJ to say that this kind of evidence can be used to determine the reasonable consumer, or the reasonably informed consumer, I guess. But it has never itself relied on that kind of evidence, or not to my knowledge, at least. As you also say, exactly.
I think well, expertise and statistics, I know, like, they are admissible as evidence in many areas. Seminally in non-discrimination, right? In non-discrimination cases, the court has in several instances kind of admitted statistics to say, well, let's say consistently men in a specific field have been discriminated against, so statistics are admissible evidence, but I don't recall any statistical evidence or expertise being used to then support an interpretation of reasonableness. But anyways, this is the topic that I'm sure that we will be able to kind of delve into in more depth subsequently. So based on that, based on like the cognitive model and then the normative model, what then would be the hybrid model? How would the hybrid model differ from the two-tier model?
Right. Yeah. So the hybrid model is also the one that gave me the biggest headaches. So I'm gonna first, just state what judges sometimes do, and then I'm gonna try to make sense of it. So what judges sometimes do is they don't ask what do people expect, but they ask what should they have expected cognitively, right? Like what does a reasonably informed person expect cognitively? So this is not a normative requirement. It is one that kind of looks at what like cognitive expectations, but it doesn't look at what people actually expect, but rather at what a reasonable person would expect. And yeah, so this is what I call the hybrid model, which would be the third model of employing reasonable expectations. And yeah, so that's the hybrid model, and it, I mean, as one might kind of guess, relies quite heavily on transparency as an underlying value.
Yeah.
And then the last and fourth model is what I call the two-tier model, and that is where where judges just employ both things. Like they first say you need to have actually expected privacy, but also that expectation must be normatively justifiable. So you first look at the cognitive expectations, and then you kind of add a second normative layer where you ask, is this also a fair expectation, kind of. So that's the hybrid and the two-tier model. Yeah.
Yeah. Okay.
Mm.
Well, I mean, these again, I would have wished that we had more time to discuss more in detail these models, but I think your book is one of the more theoretically potent works that I've read this year. So I mean, it's really really insightful and it's really powerful. But moving on to kind of like the practical application of these models, so at least the court trends where you were able to detect the use or interpretation of one or two of all of them. I wanted you to share some of your thoughts and some of your findings regarding the European Court of Human Rights case law pertaining to Article 8 of the Convention, so the right to privacy. In instances where there is personal data processing. So what were your findings there? I know that there is no like one monolithic uniform conclusion, that would apply across the board, but what would be kind of like the key elements?
Right. It's pretty difficult to see clear lines in terms of there's like overarching trends in the case law. I think that's not so, or at least my analysis kind of doesn't shed that kind of insight. So regarding the European Court of Human Rights, I think there is gradually a shift away from cognitive expectations to normative expectations. I think this is somewhat in line with a lot of research that points out that transparency and or consent are not really sufficient to legitimize data processing operations. And judges are more and more also aware of this, I think. But apart from that, I mean, there's certain kind of pockets of precedents that establish themselves and then kind of continued over the years. I think privacy expectations at the workplace have really kind of been boosted in recent years. But apart from that, it's very kind of, I guess that's also a good thing. It's very dependent on certain types of issues. There's very specific jurisprudence on kind of police investigations. There's specific jurisprudence on privacy at the workplace and in different contexts. My understanding is that there's, and I think this would also probably be in line with how the ECHR works, that there's not a real kind of stable trend in terms of we're going to think about privacy in this or that way.
Okay. So this shift from the cognitive or slight shift,
Mm.
from the cognitive to the normative model. Do you also
Yeah.
observe it in the EU now that
Mm.
we have the GDPR?
Yeah.
Is the normative model prevailing within the context of Article 6, paragraph
Right.
of the
Yeah.
GDPR, which kind of defines the conditions of lawfulness, right?
Yeah. Yeah.
In connection with personal data processing.
Yeah.
So have you been able to also maybe detect or identify specific trends in terms of how reasonable expectations apply within the context of the GDPR?
Right. Yeah. So yeah, as you just mentioned, like within the GDPR framework, reasonable expectations. One important area where they pop up a lot is Article 6.1(f), I guess. Whether there's a legitimate interest to process data, and then the recitals also state that one should consider reasonable expectations. And there, the kind of normative approach is definitely prevalent, I think. And this also makes sense because if you think about the different aspects of Article 6, so the different forms of justifying data processing, cognitive expectations obviously are quite important for consent, right? Whereas Article 6.1(f), so legitimate interests, is generally understood to be more of a kind of all things considered normative investigation, whether a certain form of data processing should be lawful or is legitimate. So their applications of the normative model are definitely more widespread and stronger, and also I think make a lot more sense. There's different reasonable expectations also play a role in other for other provisions of the GDPR. So they're quite often mentioned regarding the fairness principle in Article 5.
Mm-hmm.
And I think there the picture is a bit more unsteady. And we see both the cognitive and the normative model. And I think it also, like, if we want to talk about what model should be applied or what is like the most sensible or reasonable application of reasonable expectations, I guess, I think it's also always important to consider really the specific provision and the specific normative context, and whether that specific provision can benefit more from looking into what people expect from a cognitive perspective, or whether it should be more of a normative investigation.
Yeah. Okay.
Yeah.
Okay. Well, we are slowly running out of time, and this will be
Okay.
my last question, which in and of itself would probably be deserving of an entire podcast. But how does this then inform us on AI governance?
Oh, okay.
So
Yeah.
the best for last, right?
Yeah.
In terms of because the expectations, it seems to me, then again, I haven't really thought about this from a reasonable expectations perspective. But within the context of the AI Act, expectations seem to be framed in terms of safety rather than privacy, right?
Yeah.
But then you are dealing with technologies that are not all that predictable, which means that you do not necessarily kind of know altogether what to expect, in most of the topical problematic cases. I'm not saying that this is the case across the board, right? But in like opaque, harm-causing scenarios, So what are your thoughts? Have you done or have you begun doing some research in terms of like on AI and in the field of AI, but from the perspective of your book, which is Reasonable Expectations, and what are your thoughts on that?
Yeah, I think that's a really great question. So I haven't kind of started a project on reasonable expectations vis-a-vis AI governance or AI applications. although maybe I should do that because that sounds very interesting. So I think, I mean, like my general feeling is that what I kind of value about the notion of reasonable expectations is that coupling to social norms, or that coupling to what the subjects of these technologies, citizens kind of deem a fair way of their data being handled. And I think there is a quite noticeable shift now from the kind of overall normative ethos that the GDPR kind of operates into what is now being done with the AI Act. And I think the AI Act, although it kind of has learned from the experience of the GDPR in terms of being a lot more technically informed and being a lot more specific and viable in terms of we're crafting legislation that is really in touch with the technical issues that kind of concern this new technology that we want to regulate, and therefore we craft regulation that hopefully has kind of an impact on how that technology will be developed in the next years. I think what it kind of misses is to think about how. So I think data protection law has a stronger recoupling to A, individual rights, obviously, and B, also this notion of reasonable expectations and this notion of some form of popular justice, or like popular understanding of justice, right? So and I mean, luckily the AI Act does not disapply the GDPR, and the GDPR will of course kind of continue to also play a big role, or to play at least some role in AI governance. Although I think it's rather disappointing what we've been seeing so far from data protection authorities in that regard. Maybe there can be some kind of collaboration between these regulatory regimes, where one kind of deals more with more specific issues of safety, of discrimination, of data quality, etc., and data protection law kind of has more of the user rights and maybe democratic control aspect in mind. So that would obviously be the best outcome, I guess. Now one may speculate on what's actually going to happen in practice, but that's just some initial ideas, I guess. But
Well, in any case, much to be done, right? I mean, promising,
for sure.
Promising angle for the study of the AI Act and AI governance in general.
Let's see. Yeah.
And so to wrap up, I always also ask our guests to kind of give us a message. You know, if you were speaking to a providential legislator or a court, or a consumer, a user of AI technologies, or any type of actually new technologies, what would you say? What inform yourself? Educate yourself. What would be the message?
I mean, ultimately, I think what's like kind of at like for me, what's at the core of this project, but also what I'm interested in, is like democratic control, democratizing tech governance, democratizing technologies. So if I would talk to a legislator, that's what I would ask him, like, how can we kind of make progress with that? Because I think we're just seeing that it's a huge societal sphere, which is obviously dominated by businesses and business interests, and it shouldn't be, or it shouldn't be exclusively. So yeah, I would that's probably the tagline I would go with. How can we democratize data governance or tech governance or something?
Yeah.
Yeah.
Okay. Well, this marks, on that note, this marks the end of this conversation.
Yeah.
Thank you, Paul, so much for taking the time to sit down with me, albeit virtually, and discuss your book, which again I found extremely insightful, and we will add to the description of the podcast when we publish it. I urge anyone who is directly or indirectly interested in privacy and data protection and AI technologies to kind of have a look at this book, because it really is, again, theoretically very potent and super insightful. And I think
thank you so much.
Yeah, many of us, including myself, like many researchers in the AI field and in new technologies field in general, I think we could really use this book as a very, very precious resource. So thank you again, and
thank you for having me. I mean, it's been an absolute pleasure, and yeah, thanks for inviting me, and thanks for giving me these great questions. And yeah, it's so kind of generative to also to talk with other researchers about one's own ideas and how they get understood. And yeah, so thank you from the bottom of my heart. Really, that was very. Yeah, super great to be here.
You're very welcome. The pleasure was all mine, and surely there will be future occasions for you to kind of be included in one of the many activities that we are organizing at the Center of Excellence. So
yeah,
until we meet again, then
I'd be very excited to do that. So yeah, okay, thank you so much.
Thank you for watching an episode of the Just AI Jean Monnet podcast, brought to you by the team of the Just AI Jean Monnet Center of Excellence and supported by the European Commission through the Erasmus Plus program. Keep an eye out for upcoming podcast episodes where experts in the field of AI will delve into the significant risks posed by these technologies and propose potential solutions. Stay tuned for many exciting and insightful discussions to come.